in major cities, with the social stigma attached and unacceptance towards the disease, country was in a dire need of an act to govern the mental health care. Treatment without discrimination, patient empowerment, and right to live with dignity was another major contributor towards the formulation of the act. To speak on the issue, we are pleased to have with us today Dr. Soumitra Pathare, who is a renowned psychiatrist and director of Center for Mental Health Law and Policy, Indian Law Society, Pune. Dr. Pathare was the key person in drafting India's new Mental Health Care Act 2017. He was also a member of Mental Health Policy Group in India's first national mental health policy, released in October 2014. Dr. Pathare has also served as a WHO consultant in many low and middle income countries and had assisted these countries in implementing their mental health legislations and drafting their mental health policies. Before I hand it over to Dr. Pathare, I request respected Dr. Mahesh Devnani to say a few words, please. Sir.
Thank you, Sukhpreet. And I see Dr. Shyama is also here. So I would rather like Dr. Shyama to say a few words before we hand it over to Dr. Pathare. Dr. Shyama is the General Secretary of AHA also.
Dr. Shyama, sir, please.
Thank you, Dr. Sukhpreet, and thank you, Dr. Mahesh. Dr. Pathare, we are really honored to have you on board and look forward to hearing from you. And maybe after the session, maybe we'll have some questions with you. Thank you so much. Over to you, Dr. Mahesh.
Yeah, thank you very much. And thanks to Dr. Pathare for agreeing to my request and sparing his valuable time to share his thoughts on the Mental Health Care Act, which is very important from the hospital administrator's point of view also. And AHA for long has been trying to bring experts from different specialties to apprise about the issues which are relevant and pertinent to hospital administrators and the issues which don't get much attention from the hospital administrators because they are most of the time busy with the operational aspects and management and lean thinking and all that. So the legal and ethical issues are equally important, not just in the public sector, but in the private sector hospitals also. So really pleased to have you, sir, today, and thank you very much. So Sukhpreet, back to you. Sukhpreet, you are muted.
Sorry, pardon, sir. Thank you, sir, for your kind words. Now I hand over the podium to Dr. Pathare, please. Sir.
Yeah. Can you see my presentation? I just wanted to be sure you can see my presentation.
Not yet.
Not yet, sir.
Hold on. Something went wrong. I've never, with Meet, the presentation is always a challenge. Can you see it now?
Yeah, yes. Now we can see and
okay.
We can hear you loud and clear.
Okay, good. Okay, thank you so much. The problem is now I can't see any of you because now I can only see my presentation. That's how Meet seems to work. I don't know why that is, but that's
no, that is how it is, sir. So don't.
Yeah,
worry.
I know. So anyway, so if you put up your hand or say people do something, then I can't see any of it. Just remember that. So just bear with me on that. Thank you so much. Yeah. Okay. Thank you so much to the AHA and to Dr. Devnani for asking me to do this talk. It's always a pleasure to see that hospital administrators are also taking an interest in ensuring that they are compliant with various health legislation. So that's always a positive for me, and I'm happy to share whatever little that I know about the act with you. What I'm going to do is I'm not going to talk about the entire Mental Health Care Act, okay, because that's not what the idea is. So I have picked out bits from the act which are particularly relevant to you if you're a hospital administrator. As a hospital administrator, what are the things that you need to be looking at and worrying about to ensure that you are and your hospital is compliant with the Mental Health Care Act. I mean, that's really all I'm going to talk about. I'm not going to go into details about what is the rest of the act, what are the why did it come into being, and what are the other things that are there in the act. So it's very focused from a hospital administrator's perspective, and in that sense it is very applied. It's something that you need to worry about in your day-to-day work, is what I'm going to talk about. I was told that I should speak for 30 to 35 minutes, and then we have about 10 or 15 minutes for questions. So let me see if I can cover this all in about 35 minutes without rushing through very quickly. Okay. So the first thing that you need to understand is this definition of what the Act calls as the mental health establishment. So the Act defines what is a mental health establishment. Basically, it's any place for treatment given for mental health. Okay, for anyone with a mental health problem, any place which is providing treatment, rehabilitation, where such people, the Act uses the word where such people are admitted, reside at, or are kept in. So it actually includes everything. Okay, it includes hospitals meant solely for the treatment of care and of persons with mental illness. It includes general hospitals and general nursing homes where people with mental illness may be treated. It also includes halfway homes, sheltered accommodation, supported accommodation, all of that stuff. Okay. The law does not make any distinction between hospitals or mental health establishments owned by the central government or state government, local authority, public trust, corporations, cooperative societies, organizations, or any other entity. So basically, the law covers every hospital run by anybody, including the central and state governments. Now, the first thing that the law requires is that all such mental health establishments are registered under the Act, okay? And that is section 65 and 66 of the Act, which lays out a procedure for registration. And the procedure, I'm going to outline to you what the procedure is very quickly. If it's a mental health establishment which is under the control of central government, they have to register with what is called as a CMHA. The CMHA is the Central Mental Health Authority. Mental health establishments which are under the control of state government have to register with the SMHA, which is the State Mental Health Authorities. And all other hospitals, everybody else has to register with the SMHA. So basically, the CMHA will only register hospitals under the control of central government. Everybody else will register with their State Mental Health Authority. And the State Mental Health Authority can prescribe minimum standards for what facilities are being provided in different categories of mental health establishments. So, for example, they might say these are the minimum standards for an acute ward, these are the minimum standards for rehabilitation, these are the minimum standards if you have a psychiatric intensive care, and all of that. Okay. So they will prescribe those minimum standards, the minimum qualification of personnel, what are the provisions that have to be done for maintenance of records and reporting, and any other conditions that the SMHA might impose on all the MHEs in the state. So that's really how it works. You need a registration with the SMHA. Uh, so there are two kinds of registrations under the Mental Health Care Act. One registration is called a provisional registration, and then there is something called as a permanent registration. So what is a provisional registration? Basically, the provisional registration works when your SMHA has not yet come up with standards. So, when the SMHAs are established, they may not have design standards for what are the facilities, how are they registered and all. At that point, everyone who is a mental health establishment has to get a provisional registration. The provisional registration is extremely simple. You have to just send a letter. The letter needs to basically say that, look, we are an establishment, we admit mental health patients, this is what we do, these many beds, and whatever information that you feel is relevant, you send it off to the SMHA. The provisional registration is a deemed registration. What does deemed registration mean? That once you send it to them, you are supposed to receive a certificate of registration in 10 days. If you do not receive a certificate of registration in 10 days, the law says that you are anyway deemed to be registered. So Once you send them the details and you say, look, we need provisional registration, and you keep a copy of all of that, including the if you send it by speed post or something like that, 10 days after that, you are deemed to be registered. That's it. You don't have to do anything else at all. Okay. If the SMHA has some questions, they are supposed to come back to you. You do not have to chase them for it. And after 10 months, after 12 months, you apply for a renewal of the registration, and the renewal of a provisional registration is the same. Again, you just send them a letter, and that's the end of it. You don't have to do anything more. Now, let's say the SMHA has published standards for various categories, okay? And they've said, acute hospitals should have this standards and rehabilitation. Once they've done that standards and they've published those standards, then basically mental health establishments have to apply for a permanent registration, okay? So you can't apply for a provisional registration at that point, because then you apply for a permanent registration based on whatever particular category that you want to register for. So, and what do you have to do? You have to, as a hospital, give an undertaking and provide evidence that you are meeting the minimum
Sir, excuse
standards
me.
that are there.
PPT is not
Yeah.
visible.
Oh, not visible? Sorry, can you see the PPT? Oh,
I
okay.
have asked Shubhi to look into it. Someone else has started presenting. So,
Oh.
Mr. Ramesh Kumar, can you please stop presenting?
Somebody's else's screen was there.
Oh,
Yeah, sorry
okay.
for that. Dr. Pathare, you need to just start. Just start presenting again. We are on the last slide that you were presenting.
Can you see them now? Okay, hang on. I will. Should I just stop sharing and present again?
Yeah. Just once you
Okay.
stop sharing and reshare it again.
Sir,
One
now it
gentleman,
is visible.
Hang on. I'm just going to do resume presentation, and that should come.
Yeah. Now it's visible.
Yes,
Yeah.
sir.
yeah.
Okay.
So go ahead.
Okay, I'll use it like this only but I can't. Well, I'll have to.
No,
go
no.
back.
Someone else started presenting in
No,
between.
this, sir, you can present it like this, sir. No worries. That way you can see the screen
Yeah,
and we
yeah,
can
yeah.
also see you. Let it be like
But
this.
then I can't. What happens is I can't actually move the slides though. That's the only problem. If I have to
Is it?
move the slides. Yeah,
Okay.
I have. Hang on. I'll go back to it. Now you can still see it, no?
Yeah.
Yeah.
Okay.
It's
Sir,
visible.
You
now
can
it is
still go
visible.
down on, you can just keep clicking the next slide and it will go.
Yeah. Okay. Just tell me if it does. So this is what I said about provisional registration, and I was talking about permanent registration. For permanent registration, you have to then give an undertaking saying, look, these are the minimum standards. This is how we meet the minimum standards. You send it off to the SMHA. The SMHA will put it out online or whatever for 30 days. If anyone has any objections, they will come back to you and tell you, look, these are the objections. You get a chance to reply. If there are no objections that they receive, then basically within 45 days, the authority has to grant you a certificate of permanent registration. Okay. There is no inspection that is required by the SMHA. So the SMHA does not have to do an inspection. The SMHA basically has your undertaking. So they'll ask you to file an affidavit saying, look, we meet the minimum standards and all. And based on that, you are going to be registered. If you don't hear back from them in 45 days, okay, you will be deemed to be registered anyway. So really the process for registration for hospitals has been made very simple, and the entire onus of objections or anything is completely on the SMHA. So the SMHA doesn't come back to you. You don't have to worry. You have done your job. You are registered as far as the law is concerned. Okay. Now, let's say if the authority does come back to you and say, well, these are your deficiencies, we don't agree with this because these are the objections we got, then you have time for 6 months, within 6 months to rectify the deficiencies and apply afresh. Okay, so during that 6 months, they will say, fine, we're giving you a registration, but you have 6 months now to rectify that, and then you go back again and provide evidence that you rectified those things, and so your registration will be done properly. So again, as I said, you have time. It's not something that is going to be a problem. Now, even better is what the Mental Health Act says is that if you are already registered under Mental Health Act of 87, then you're deemed to be registered under the MHCA. So if you're already registered with some other act, you will be your registration will continue. Not only that, if it says that if you're a mental health establishment which is registered, say, under the Clinical Establishments Act or any similar act like the Clinical Establishments Act, then you're automatically deemed to be registered under the MHCA. So let's say you're a general hospital, you're registered under the Clinical Establishments Act or the Bombay Nursing Homes Act, you're deemed to be registered under the MHCA. The only thing you have to do is you have to send a copy of that registration to the SMHA along with an undertaking that, look, we fulfill the minimum standards that you've specified. So that's all you have to do, and that's the end of your registration process. So once you've done that, so every general hospital just has to basically say, look, here is our registration under the Bombay Nursing Homes Act. We are already registered, or under the Clinical Establishments Act. And yes, we have the facilities for providing psychiatric treatment. This is what our facilities are. Please kind of register us with you. And once you've done that, your job is over. If you don't hear back from them for 45 days, you are deemed to be registered. Then that's the end of your work that you need to do for registration. You do have a duty to kind of display that your registration. Okay, so you have to display on your registration, as well as you have to put the contact details, address and telephone numbers of the mental health review board. So there is a mental health review board that is set up by the SMHAs, which will review any complaints and all. So basically you have to ensure that that information about that is displayed in your hospitals, and that you also provide people with the necessary forms if they want to complain to or apply to the necessary concerned board for anything. Now, when it comes to admission, treatment and discharge, I can stop here for a minute and take any questions. Maybe that's the best way to do it. So as far as registration goes, do people have any queries or questions?
I have one question for you, sir.
Yes, yes, yes.
So this is regarding the registration that you talked about in 65 and 66, that it is
Yes.
deemed naturally to get registered beyond a certain period
Yeah.
of time. But the I am coming from NABH standpoint. NABH insists that you should have a certificate in hand, whereas many states, say for example Rajasthan, has not taken a stance around this at all under Mental Health Act. So
Well, you basically you'll have to go. I mean, I know this is a problem. People have mentioned this to me, but you know what? NABH will have to change its own processes. The law will not change. You see what I mean? So NABH will have to change and say that, okay, show us proof that you applied for the registration and 10 days have gone past that, or 45 days have gone past. And if you give them proof of that, they go, this is the affidavit we filed, this is the speed post letter we sent them, this is what we've got, this is our evidence, 45 days are over. As far as we are concerned, we are registered.
sure.
It's the NABH which will have to change. The law will not change, if you know what I mean.
Sure. So yeah. So maybe somewhere we as academy should also write to NABH saying that this is what is the change in regulation.
Yes.
So kindly look into
Yes.
this and change your regulation. Okay. Thank you so much.
Absolutely.
Right. Thank you. Yeah.
Anyone else?
Yeah, hello.
I have a question.
Okay, let's take one by one. I'm going to just go off the screen and come to the window where I can see all of you. Yeah, okay, let's take questions. Mrs. Sai Chapalgaonkar.
Yeah, hello, sir. Good afternoon.
Yeah.
I wanted to ask, what is the validity of a permanent registration? Do we need to apply for the audit?
The permanent registration is, as it says, permanent. You don't have to keep on applying.
Right.
Yeah.
That is logical, but do we need to apply for the audit, or that will be automatically done by the authority?
The
After
audit
3 years.
the audit is supposed to happen every 3 years.
Yes, sir.
And really it is the SMHA which has to conduct the audit. You can't do anything about the audit, because every 3 years the SMHA is supposed to appoint a committee to then carry out an audit, and it's supposed to be a social audit. So they're supposed to appoint a committee. You as the hospital really can't do much about it. And if the audit does not happen, then that's not your fault. It is their fault.
Okay, sir. Recently, we have received our permanent registration. I'm from Maharashtra, and they have done hospital audit before sending the registration copy. Yeah.
Okay, that's good. If they're doing that, that's their choice. But it's not your responsibility to do the audit.
Okay, sir. Thank you, sir. Thank you.
Yeah. We have another kind of question. Dr. Rajendra Rai wants to ask a question.
Yeah.
Dr. Rajendra Rai, sir, please.
Thank you, sir. Sir, the last minimum standard is for blind people. Sir, do we have to follow it in letter and spirit, or we can spare it, sir? Please.
You will have, you mean the minimum information has to be displayed for blind people? Is that what you're asking for?
No, sir. Structural changes in flooring.
The Mental Health Act does not ask for it, but if the Clinical Establishments Act requires you to do it, you'll have to do it.
Okay, sir. Thank you, sir.
You know.
And any more questions, please? If anyone
Yes, sir,
wants to.
excuse me. I do have a question, sir.
Yeah, go ahead. Girish Deshmukh.
Right, sir. Yes, sir. Good afternoon to you, sir. I'm calling from Pune,
Good
sir.
afternoon.
In my hospital, sir, we are not admitting psychiatric patients, sir, but we are registered under
Okay.
Bombay Nursing Home Registration Act. But we are running
Okay.
a psychiatric OPD, and the OPD, matlab, we are having quite a lot of patients, sir. We are
Yes.
also doing electroconvulsive therapy on OPD basis. Now, my
Right.
question is, sir, are we supposed to mandatorily be registered under this Mental Health Care Act?
You're not supposed, if you only run an OPD, the law does not require you to register. It basically requires you to register if you are having inpatients admitted to your hospital. Now, the only
Right, sir.
the question comes up is, what is the definition of inpatient care? That is really what it comes up with. So, for example, let's say you have day patients, okay? If you're going to admit
Yes, sir.
somebody for a day after an ECT, then
Sir.
clearly, somebody at the SMHA could stretch the rule and say, well, you are admitting them for a day because they're day patients, because they're getting an indoor admission being done for them. So
Yes,
you
sir.
please register. So you please register. So they could ask you that. If and also my suggestion has always been the other way around. In fact, let's say you're a general hospital and you have
Yes, sir.
an intensive care unit, or let's say you
Yes,
have
sir.
a general ward and somebody develops delirium or develops psychosis and you need to treat them. You might
Yes,
as
sir.
well register, because registering requires you to do very little effort. Registering requires you to basically say to them, listen, here is our registration under the Bombay Nursing Homes Act, and we are treating people for, let's say we are doing ECTs. These are the facilities that are available with us for ECTs. We treat general ward patients. These are the facilities in our general ward patient. Please register us. And then
Yes.
the ball is in their court to say, well, we are not going to register you, or we don't need to register you, which is fine. Then you are safe. So I would just
Okay, sir.
encourage you, because there's really nothing that you have to do to register. Like it literally is like send a letter to them. It's the effort involved is so little that allowing the SMH, because the SMHs can interpret it whichever way they want. It comes down to a matter of interpretation.
Yes, sir. But sir, my next question is, now we
Yeah.
are admitting different and they are being admitted
Your
under
voice is breaking.
Sir, your voice is
Your
breaking.
voice is breaking up. Your voice is breaking up. Can you repeat it? I didn't hear what you said.
I'm afraid. I'm sorry, sir. My question was, sir,
Yeah.
that right now we are admitting, as you rightly brought out, sir, these delirium and dementia patients, but then we are admitting them under neurophysician and not under psychiatrist, sir.
That does not matter. The law does not work on the basis of under who they are admitted. The law is working on the basis of what medical condition they have.
Sir.
You see, the law is not defined by the clinician treating them. The law says any person with mental illness. Now, if a person with dementia or delirium is a person with mental illness, who they are admitted under then does not make a difference.
Right, yes, sir.
Yeah.
Okay. Thank
Sir,
you so
Mr.
very much,
Mazid
sir.
has raised.
Thank you. Yeah, Mahajan.
Sir, please
Yeah,
introduce yourself
I,
first, please, sir. First.
yeah, I'm Dr. Mahajan. I work as a nodal officer for mental health and addiction treatment services in J&K. And recently, we have not set up state mental health authority yet. But once I went to my secretary about this, that it is long overdue. He said, do union territories have to make their state mental health authorities as such? So I had no answer for this. So
I think the answer is that yes, union territories should set up their mental health authorities, unless the union territory has decided to have some agreement with the CMHA and said, all people in here will go and register with the Central Mental Health Authority. Now that is actually going to be very difficult for people because the CMHA is based in Delhi and the Union Territory is like Kashmir may be close to Delhi, but there'll be other Union Territories which are miles away from Delhi. And then remember, imagine having to go to the CMHA each time, every time you need something from the Mental Health Authority.
Okay, sir. Thank you. Thank you very much, sir. Thank you.
Do we have any more questions? If no, we can continue.
Okay.
Sir, I see no questions are there. So
Okay.
please continue,
Thank you.
sir.
Thank you. Hold on a second. I'll just go back to the presentation because that's how I can work with it. Okay. Okay, so I've got the registration thing covered. As far as admission treatment goes, in terms of admission, there are 4 kinds of admission. Okay, the first is what is called as independent admission, which basically is what it previously would be referred to as voluntary admission. Okay, now that is, sorry, somebody is saying something. Hello. Okay. So independent admission means basically a voluntary admission, and a voluntary admission is very similar to the admission that you will do for any physical illness completely. Okay. So in that sense, the law does not have much to say about the independent admission, and I'll tell you a little bit if you want, but really independent admissions as a hospital administrator, you don't have much to do other than to ensure that it is a genuinely voluntary admission that is happening and all of that. You have to ensure that it is a real voluntary admission. Then there's the issue of supported admissions. I'll come to the minors later, which really is what used to be called involuntary admission. And that is divided into 2 parts. Involuntary admission, as it used to be called, is supported admission up to 30 days and supported admissions after 30 days, beyond 30 days. Okay, and for these 2 things, as a hospital administrator, you do have some responsibilities. And also you have some responsibilities when it comes to the admissions of minors. Okay. Now, I'm not going to tell you a lot about independent admission because, as I said, it's a voluntary admission. The only thing you have to be sure is that the person who is being admitted has the capacity to give consent and can voluntarily consent. So you need to be sure that your doctor is admitting somebody under a voluntary admission. It is a genuinely voluntary admission and the person is consenting to be admitted. What you also have to be ensuring is that you do not allow admission under voluntary admission if the person is not able to understand the purpose of admission. That means they have no capacity. Somebody who is confused, disoriented, who cannot give consent. Anyone who cannot give consent to a voluntary admission should not be admitted as a independent admission. Okay, so really that's the main thing that you have to remember in the voluntary admission, to ensure that when a person is admitted in your hospital, they are admitted because you're sure they were able to give consent for that admission. And that's really all you need to know as a hospital administrator. I'm not going to go further on it. The only other point to remember here is that, all admissions, and this applies not only to voluntary admission, but also to the supported admission, you have to ensure that the staff of the hospital have informed the person of their right. Okay, what are the rights that they have under the Mental Health Act, and that they can actually discharge themselves when they wish to get discharged. Okay. And all the treatment that has to happen for people who are independent patients is basically with their consent, and it is being provided with informed consent given by the person, and this should be documented in the medical notes. Now, when it comes to discharge, what can happen? Now, normally this is where the Mental Health Act is slightly different from what would happen in a physical illness. In a physical illness, a patient voluntarily admits themselves, they have the right to discharge themselves. So here also there is a right to discharge. However, this right can be overruled by the mental health professional. So the psychiatrist who's at your hospital can overrule that under certain circumstances. Okay, so if the psychiatrist feels that, look, this person is now quite seriously ill, they are not able to make decisions themselves, and that they actually might fulfill the criteria for a supported admission, so I'm going to prevent your discharge for 24 hours to get all the procedures for supported admission to happen. Okay, so that's basically these are the criteria really which are there for supported admission. And you'll have the psychiatrist saying, look, I'm going to put you under a supported admission, so for 24 hours I'm preventing your discharge. I'm going to get all the procedures done for the supported admission. So this is slightly different for independent patients as it is for, let's say, voluntary patients with a physical illness. And then a Section 89 admission has to be done, and then the assessments have to be carried out. If the criteria under Section 89 are met, the person is admitted as a supported patient. If the criteria are not met, then basically either at the end of 24 hours or as soon as the assessment is done, you basically discharge the patient. Okay, so that's what happens with the involuntary patient, which is called an independent patient. Now, what happens for supported admission? So what do you have to do for supported admission? Okay, so what the first thing that you need is that you need an application. Somebody has to apply to the hospital in charge saying, look, I want this person admitted as a supported admission in your hospital. And who makes the application? It is made by the NR. NR stands for nominated representative. So there is a notion of a nominated representative in under the Act, and I can show you one slide later on what is a nominated representative. So the NR makes the application to you. Once the NR has made the application, you need to see that you have two certificates, okay? Two certificates by two people. Who are the two people? One of the two persons has to be a psychiatrist, and the other person can be any mental health professional or even a medical practitioner, a general medical practitioner. And who is a mental health professional? A mental health professional includes a psychologist, a social worker, or a psychiatric nurse, all of whom are registered with the state mental health authority. The SMHA will be running a register of all the nurses, all the psychiatrists, all the psychologists, all the psychiatric social workers. And if they are registered under that, they fulfill this criteria of being a mental health professional. But if you don't have that, any medical practitioner. So one psychiatrist and one medical practitioner have to give the certificate. And basically, they have to examine the patient independently and give a certificate saying what is written here under the second bullet. Okay, which in plain English, it means that they are saying this person has a mental illness of a severity that they can't make decisions on their own. And one of these three things has happened, okay, which is that they're either threatening harm to themselves, or they're threatening or harm to someone else, or they are unable to take care of themselves to the extent that they are putting their life at risk because of that. So one of these three things along with a mental illness, and you will get that certificate. Once you get a certificate, what you need to do is, I'll forget the first two bullets, come to the third bullet, report the admission to the concerned board. So once you get the certificates and you have the NR's application, within 7 days, you have to report this admission to the mental health review board. There will be a mental health review board for the district where you are based. You have to send the information by post. You only have to send the information by post. You do not need permission from them. Let me clarify that, okay? If it is a woman or a child, then within 3 days, you have to send the information. For everybody else, you have to send the information within 7 days. You also want to check if there is an advance directive, and you want to basically ensure that the psychiatrist is then going to follow treatment according to the advance directive if it exists. I will tell you at the end what is an advance directive, so that don't worry about it now. But basically, you need to ensure that you have checked whether there's an advance directive or not. Okay. So that's really what you need to remember for a supported admission. And as I said, if there is an advance directive, then the patient is treated using the advance directive. If there is no advance directive, then the informed consent has to be taken. And in this case, the informed consent is given by the nominated representative. This is the person who made the application. Okay. And basically that is called as temporary consent under the Act. And so every 7 days, your psychiatrist has to put in the note saying the patient is either not recovered their capacity to consent or has recovered. If they've not recovered their capacity to consent, then basically the NR will continue to give consent till they recover capacity to consent. So you need a consent either of the NR or of the patient itself. In a supported admission, what you're saying is that, well, patient can't consent, so the consent of the NR is being taken, and every 7 days your psychiatrist makes a note in the medical note saying, look, this person is still not recovered, that they can consent on their own. So that's really what, so you need to ensure that this documentation has happened. Now, what happens if you want to discharge this person? Okay, discharge. If you want to discharge this person before 30 days, that's it. Your medical officer or the psychiatrist will recommend discharge, and you basically discharge them, or they can continue as an independent patient. If you feel that, oh, now they don't need to be a supported admission, but they need to continue in hospital for some time, you can continue as a independent admission. And at the end of 30 days, they either get discharged or you move them to the next supported admission, which is the admission beyond 30 days. So you can again, what I'm trying to tell you is that for the purposes of discharge, you do not need anyone's permission or anything. Okay, so nothing has to be done. Your psychiatrist, who is in charge of their treatment, makes the decision to discharge, and they can be discharged, and that is the end of the is where it ends. If you want to continue the admission, then there is a different process to follow. So at the end of 30 days, let's say they decide, no, I feel, let's say psychiatrist says, look, I feel he still needs admission under a supported admission because he still does not have capacity to consent. So they will have to basically move this person to a, hang on, I will come to the slide. Okay. That's it. So if they want to continue admission after 30 days, then they admit them under section 90. Okay. So now what is the procedure for section 90? The section 90 procedure is the same as the section 89 procedure, except few things. Okay. So you still get the nominated representative to make the application. And the only difference is here now you need two psychiatrists. You remember in the previous one, it was one psychiatrist and one medical practitioner. Basically, you need two psychiatrists, not one psychiatrist. Now, you need two psychiatrists to give you the medical certificates. The medical certificates are the same, no difference at all. And now the reporting is that within 7 days, you have to inform the board, which you had to do then also. The only difference here is that the board is supposed to give you permission or an order to discharge within 21 days. Okay, so within 21 days, the board is supposed to write to you and say, look, continue the admission or don't continue the admission. The act basically says that if you don't hear anything from the board, you continue doing what you're doing. You continue doing it till you hear from the board. If you don't hear back from the board, then it's not your problem to say, oh, 21 days are up, I haven't got any permission from the board. It is the board's problem. If they don't write to you, then it is presumed that they have no problem. Okay, so the onus again here is on the board to kind of follow up with you if they want to have some question about the continuing admission. Again, the same thing follows, which is that you need to have an advance. If there's an advance directive, you follow that. This is stuff that the board can ask. So I'm not going to it. But again, if you take informed consent, the informed consent in this case will be the nominated representative. So in that sense, all of this is same as it was for section 89. So section 89 and section 9 differ in very small respects, which is you need two psychiatrists and the board has an option to review that admission. The first time you get a section 90 done, it is for 90 days. After 90 days, if you want to further renew it, it gets renewed for 120 days. You follow the same procedure. After 120 days, if you want to renew it, it will be renewed for 180 days. And then subsequently again for 180 days. So at a time, you'll get a 180-day renewal. So idea behind this is very simple. The law expects that most people will get well within 30 days and be discharged home or be well enough to be treated as voluntary patients. Very small number of people will require, say, involuntary admission to continue for 3 months, and even smaller number will require 9 months, and even smaller number will require 3 months and then 6 months. So those who require 6 months, and there'll be people in long stay mental hospitals who might require 3, 4, 5 years. Then every 6 months you get the board to basically you go through the process of doing section 90 every 6 months, and you get the board's permission at it. But beyond that, there is really nothing else that you have to do as hospital administrators. So as hospital administrators, your role is to ensure that the certification is in place, the information has been sent to the board, that the consent of the nominated representative has been taken, and that the psychiatrist is reviewing the mental state of the patient every 6 months for capacity to consent. So you need a line in your notes to come in every 7 days saying, I've reviewed this person, they still don't have the capacity to consent, and so we shall continue to take consent from the nominated representative. When it comes to admission of minors, now here now again it's the same process which is followed, that the nominated representative has to submit the application. But in the case of minors, by default, the guardian is the nominated representative. So the guardian or parent of that minor has to apply. And again, here the admission will be like it was for 89, which is one psychiatrist and one mental health professional, or one psychiatrist and one medical professional will basically have to kind of certify that they need this particular admission. And the criteria are very simple, which is that they have a severe mental illness, that the best interests of the minor will be taken care if they are admitted, then mental health care for this minor cannot be provided unless they get admitted, and community-based alternatives have not worked or are unsuitable for this minor. So the psychiatrist will have to, and the medical practitioner will have to certify these 4 things are happening. And once you have those certificates, you admit them. And what you have to do is you have to inform an admission to the concerned board within 72 hours. Again, as I said, it is an information. You don't need any permission from them, and information can be transmitted to them either by post or by email if they have an email, and then you've got a record of it that you sent it that. And the board is supposed to carry out a review within 7 days of being informed. Again, it is the board's responsibility to do the review. If they do not do the review, it's not your problem. You don't have to worry that, oh, they didn't come and do a review, now what am I going to do? You just continue the treatment as you're doing. That's not your responsibility to ensure, because the law does not say that unless the review has happened, you can't continue treatment. The law says you continue treatment. It's the board's job to do the review. The only difference to remember with treatment of minors is that the minors should not be admitted into a ward with adults. They should be admitted in an environment which is suitable for the minor's age. So if you admit the minor in a pediatric ward where other pediatric patients are there, that's completely fine. And the second is that the nominated representative or some attendant who's appointed by the nominated representative has to stay with the minor during the admission in the ward. Okay, so they can't just admit the child and disappear off. That's not allowed according to the act. So you'll have to ensure that the parents are told, like, listen, if they are being admitted, you will have to stay here with the patient till they are admitted in the hospital. And all patients are supposed to get a discharge planning. Okay, now this doesn't apply just to minors, it applies to everybody, which means discharge planning, meaning when anyone is discharged from the hospital, either an independent patient or a supported admission, then basically you have a discharge plan which is made, the treatment is outlined in there, and it is documented as to who is going to be responsible for this person's care once they are discharged from the mental health establishment into the community, whether it is another psychiatrist or the same psychiatrist or whatever. That discharge plan has to be documented, and a copy of the discharge plan has to be given to the patient, the nominated representative or family or relative, whoever it is, so that they know, look, this is the discharge plan that has been made. Again, not anything different to what you normally do anyway. So this is just formalizing the stuff that you would otherwise also do, which is you'll give people a discharge plan when they are discharged. I will stop here and then come to the whole issue of advanced directives. But about admissions, I'm happy to stop here and take a few questions, because there might be quite a few questions here. Yes, sir. Mahesh, you have a question.
Yes, sir. If I understood correctly, it means that any minor that we admit in psychiatry ward or in any other hospital, that admission is under. Sorry.
No, I'm saying any minor you admit for a psychiatric condition, for a mental health condition.
Correct. For the psychiatric condition, all those
Yeah.
admissions are under Section 87, right? It's not like in adults, there
Correct.
are involuntary admissions. So there are no
Correct.
involuntary type of admissions. All admissions are under
No.
Section 87 and are to be informed as prescribed in the Act. To the
Yes,
applicant
yes,
authority.
exactly. So Section 87 is a little bit between independent admission and supported admission. You know what I mean? It has features
Yeah.
of both, but it is closer to the supported admission than, because the idea is that minors can't be voluntarily admitted. You understand what I mean?
Yeah. Thank you.
Yeah. Anyone else?
No, sir. It seems nobody has any questions. You please.
So you're clear of hospital administrators what you have to do for admission. Okay, I'm glad. Because
Yeah, this is wonderful, sir. This is wonderful. Please take more time if need. That's fine with us. So, yeah.
Okay. Okay, let me go back to my presentation. Okay, so now what is an advance directive? Okay, the Mental Health Act introduced something called as advance directive. In fact, the Supreme Court has used the advance directive in the Mental Health Act to frame the advance directives for passive euthanasia. If you read the passive euthanasia judgment, the Supreme Court actually refers to the Mental Health Care Act and says, look, there is advance directives in the Mental Health Care Act. So Parliament is okay with with advance directives, and based on those advance directive criteria that are in the Mental Health Act, we are framing the same advance directives for passive euthanasia. So it follows very similar with some changes to it. Now, what is an advance directive? Basically, an advance directive is a way for someone to say, if I become mentally ill and I'm not able to make decisions, let's say I become mentally ill, I lose capacity to make decisions, then basically I want the following way my treatment to happen. I don't want the following way my treatment to happen. And this is the nominated representative. This is the person who should decide on my behalf when I am not able to make decisions. Okay. That's the three things that an advance directive can contain. They don't have to contain all three things, but these are the maximum of three things that they can mention: the treatment they want, the treatment they don't want, and who is going to be their nominated representative. Now, who can make an advance directive? Everyone can make an advance directive. You don't have to have a diagnosis of mental illness to make an advance directive, because no one knows when people will develop a mental illness. So if all of you, you have to understand, advance directive is like a will. You know, in fact, in many countries, it is also called as a living will. Okay. So this is like you write a will saying, look, if I die, I want following things happening to my property. What this is saying is that if I become incapacitated in such a way I can't make decisions, then I want the following decisions to be made, or this treatment to happen, or that treatment to happen, or not happen, or whatever. And so everyone, including you and me, can make an advance directive saying, if I become mentally ill, what to do for myself. So now, if there is a procedure that the CMHA has outlined for making an advance directive, they're supposed to write it out, and it has to be registered with the Mental Health Review Board. Okay, so the advance directive has to be not only like with a will, you go to the registrar and register it. The law says that that the advance directive has to be registered. And when can you make an advance directive? The advance directive can only be made when you're not mentally ill, as in you have not lost capacity to make decisions. So you need to be in a position where you have the capacity to make decisions. Same thing like you do with a will, for example. You know, you can't make a will if you don't have the capacity to make decisions. And the mental and an advance directive only comes into force when people lose capacity. So when they lose capacity, so if they are admitted under supported admission and there is an advance directive in place, then you have to follow the advance directive during the supported admission. Okay. If somebody's got multiple advance directives, then the latest advance directive is the one you have to follow. You don't have to, if somebody gives you 4 advance directives, there'll be dates on it. The one which is the most latest is the one you follow. There are ways to review and alter and cancel an advance directive, which I'm not going to go into detail with. But basically, somebody has to go to the review board and say, look, this advance directive is wrong, or this advance directive should not be followed for the following reasons. And these are the reasons. The middle panel here, it says these are the reasons. You know, that the person didn't make it out of free will. It was not intended to apply for this circumstances. The person was not well informed when they made it. They didn't have capacity. Or that it is contrary to some law or constitution of India. So, for example, if somebody wrote in an advance directive saying, if I develop schizophrenia again, please euthanize me, you know, give me euthanasia and kill me. Now that's against the Constitution of India. No doctor can follow it. So basically, you just go to the board and say, look, we can't follow this advance directive. This is against the law of the land. And the review board will then cancel that advance directive. Now, the important thing about the advance directive is this. Okay? It is not your job as a medical practitioner to go hunting for an advance directive. Okay? Whoever makes the advance directive, it is their job to ensure that when the doctor needs the advance directive, they hand it to them. So if nobody gives you an advance directive and the person is getting admitted as a supported admission, you are not liable for anything. Okay. You don't have a liability, because if they have an advance directive hidden away in their cupboard at home, which you have no access to, it's not your job to go hunting for that advance directive. And secondly, if you if you follow the advance directive and do what is in the advance directive and something goes wrong because of that, so for whatever reason, if I'm ill, please don't put me on a ventilator, it's okay if I die, and then they die, then you will not be held liable because you have done what they wanted in the advance directive. Now, I know that a ventilator is not the issue for mental illness, but I'm giving you that as an example to explain to you that following the advance directive, what is in the advance directive does not create a liability for the mental health professional in case there is an adverse outcome. So the law protects you from that adverse outcome. So the law basically provides you with two protections as mental health professionals: that not your job to go hunting for an advance directive, and not your problem if there is a bad outcome because you followed the advance directive. And then the law says you have to follow the advance directive. So you understand, the law provides you protection and then you. That's really what it is. Now, in terms of a nominated representative, basically, the law says that any person with mental illness can appoint a nominated representative. Basically, a nominated representative is really close to what you are normally doing, which is you're saying nearest relative. The law is calling it a nominated representative. And why is the law calling it a nominated representative? Because you can appoint anybody. Okay, you can appoint. It doesn't have to be a relative. It can be your friend, it can be your spouse, it can be anybody you wish to appoint. The nominated now, if somebody is not appointed, you'll say, okay, what if there is no nominated representative? This person never appointed an NR. So the law says there is a default list. Okay, so the default list would be in the following way. If they are not appointed, then you look in the advance directive. Is there an NR mentioned in the advance directive? Okay, there is none. Then the relative will have to act as the advance as the nominate as the NR. Now, if there is no NR, if there's no relative, then, well, any caregiver who's there will be the NR. Let's say there's no caregiver also, then some person appointed by the board will act as an NR. And until the time the board appoints someone, the director of social welfare is the nominated representative. And what the social welfare department can do is they can say, oh, you know what, if for temporarily some registered organization working with people with mental illness can act as a nominated representative. Now, in public hospitals, if a homeless person is brought in, this is where the problem will happen. When a homeless person is brought in, who is the NR? Well, the Department of Social Worker can social welfare could, for example, have a standing order issued saying that if a homeless person is brought to a public mental hospital, then the Rogi Kalyan Samiti, which is an NGO, will be the NR. And the Rogi Kalyan Samiti can say, oh, the social worker in our hospital who's part of the Rogi Kalyan Samiti is the NR for every person who's homeless and is being admitted under the Mental Health Act. So then that social worker basically files the application for the NR, which will be required for Section 89 admission. Yeah. So that's how the NR process works. So everyone is covered under that. And basically an NR really functions like the same as a person would function. You know, like whatever are the rights that you have as an individual, you're basically transferring those rights to the NR to act on your behalf, because you're not able to make decisions and you're not in a state of mind to make a decision. So that's really the issue of advanced directives and nominated representative. Again, as I said, I'll just stop here for a minute and you guys can ask me some question if you need any clarity.
Anybody?
Yes, Rajendra Rai.
So please introduce yourself and you can ask a question. Hello.
Mr. Rai, Dr. Rai.
Audible,
Yeah,
sir?
yeah, you
Thank
are.
you, sir. Thank you, Dr. Supreet, sir. Sir, this advanced directive is, I think, also a social stigma, because a person, how he can say he will be having mental illness after so many days or few days, and how he can decide this type of treatment can be given. I think this is against
The
the
advanced
Montgomery
dire-
case.
the advanced
Yes.
directive is not a compulsion. Nobody has to. The law does not say that you have to make an advanced directive. The law says if you wish to, you can make an advanced directive. So it's an option. Just like writing a
Yeah.
will, the law does not insist you write a will, but the law gives you an option to write a will if you wish to write a will. If you don't wish to write it, don't write it.
Sir, that's the case. The patient don't know how many types of treatment are there. Just like in Montgomery case, we have done so many cases also, sir. So I want, sir, some experts comments from you, sir.
The point is that I know what you're saying, but the law is basically saying that people make the choice. Basically people will make a choice. If people don't want certain, if somebody writes in an advance directive that I don't want ECTs, then they don't want ECTs. End of the story. Whether it's good for them, bad for them. It's the same like somebody might say, I don't want to have surgery, I'm happy to take medicines, but mujhe surgery nahi chahiye. So that's how it is. We don't do surgery because they don't want it, because this is a choice which is being made by somebody when they have capacity to make decisions. If they don't have the capacity to make decisions, the advance directive is anyway not valid. So a valid advance directive is when people have the capacity to make decisions. When you have a capacity to make decisions, you make wrong decisions, you make bad choices. That is how life works. Unfortunately, but that's how it is. Our patients always make choices. Sometimes they make bad choices. Sometimes they make good choices.
Yes.
As long as they have the capacity to make those decisions, as long as they have the capacity to make those decisions, they have the right to make those decisions. Bad and good are very subjective terms that will come into it. What you have to ensure is that when the advance directive was made, did they have capacity to make the decision? If they had it, that's it. Then it's a valid advance directive.
Okay, sir. But they can make wrong decisions also, sir.
We all
That's
make
right.
wrong decisions. We all invest money into wrong schemes and lose our money and go bankrupt. We are always making wrong decisions, sir, about many things.
Okay. Okay, sir. Final, sir. Thank you, sir.
Sir, I have
Sir,
a follow-up
Yeah.
question to what
Yes,
Dr.
yes,
Rai
Dr.
asked.
Devnani. Yeah.
Even for
PPT
someone
share
like,
kar dena.
the recording will be available, Dr. Rai. The recording will be available on YouTube with the permission of
Thank you.
Dr. Pathare.
Yeah.
Thank you.
So, sir, what I was asking, that even for someone like me who has a medical degree, it might not be very easy for me to decide what is the right approach of treatment if, say, in future I am in a
Correct.
position where I
Correct.
need to.
Correct.
So, what could be some examples which people say, ki, I want this type of treatment or not this? I understood you said ECT is not, I don't want the ECT. But what could be other examples which could be written?
We did some research on advanced directives. Okay, we did some research on advanced directives with people now in Chennai and one more city, I forget which one. And we published papers on that. I'm just telling you what people have said in that. Okay. And what we found, because we did this where we told them, why don't you write an advanced directive? And we asked them to write those advanced directives. These are people who have long-term mental illness and have been repeatedly admitted or were being treated. The interesting thing was that, like, out of the 110 people who were asked to write the advanced directive, I think only one person said that I don't want any treatment, even if I become ill. So there was 1 out of 110 who said that, 1 or 2, something like that. And most of the people, quite a few people said, I don't want ECTs. Okay. Some people said, I don't mind having ECTs, but anesthesia, don't direct ECTs. Okay. not give me Serenade. I get side effects because of Serenade. Please use some other medicine next time I become ill. Please tell the doctor Serenade gives me side effects. Don't inject me with Serenade. So a lot of people were writing those kind of things which was like, this is my experience, please avoid this or please avoid that, or like somebody had written, if I need admission, I don't want to be admitted to this hospital. This is a very bad hospital, you know, and they had named the hospital. I don't want to be admitted to that hospital, please. I will not get admitted to that hospital. Please ensure that I don't get admitted there. Some people had written things like, women especially had written things like, when I become ill like this, I don't want my husband to make these decisions. I want my father or brother to act as my nominated representative. So, people are using it to actually be very precise about what they want. And a complete refusal of treatment was extremely rare, is what we found, this idea that I want. Yeah.
Is it legally tenable, like the doctor has to follow if the patient is saying, I don't want any treatment for the mental illness in the advance?
If what you will have to do in that case, if that happens, for example, if somebody did do that, is you will basically have to go to the board and let the board decide whether this advance directive should be followed or not. If the board says follow it, then well, you follow it, and then you say hum kya kar sakte hai, because the board is supposed to be headed by a district judge. Okay. So the board will have to take a decision ki follow karna hai ye ki nahi follow karna hai. And the board will have to follow a procedure. If the board says don't follow it, very good, don't follow it. Good. Because see, when you write an advance directive like that, where I say I don't want any treatment, I'm also taking the risk that the board will overrule me, and then I have no control on what is happening.
Correct.
You see what I mean? So you're taking a risk when you write something like that. On the other hand, if you write more specific things, saying my husband should not be my NR, but my father should be, I don't want haloperidol, it's more likely it will get followed anyway.
Yeah.
So yeah, it's a matter of things that will have to evolve over time on this.
Yeah.
So we have a question from Dr. Shyama Nagarajan, ma'am. Ma'am, please.
Yeah, go on.
Yeah, sir, just a corollary to what Dr. Mahesh just asked. See, certain times it so happens that, even if you have an advance directive or something, the relatives may end up saying that, this is what we suggest he does not understand, and this is what has to be done. And typically these kind of conditions actually leads to violence within the hospital.
Correct. So you just, I know. So
and other issues. So
what you have to do, you have to do in that sense is show them the law, tell them you don't want us to follow this advance directive. I'm very happy to do that. Please go to the board and get the order from the board, and I will not follow the advance directive. They can appeal to the board. As I said, I showed you a slide that they can appeal to the board and tell the board, ye advance directive mat follow karo, and they have to convince the board why the advance directive shouldn't be followed.
No, but there is a time lag for that. So the patient
there is a time lag, but there is a time lag, but you have to tell them that, look, this is the situation, this is the law, what can I do? I can't, because if you break the law and you say that, oh, I'm going to overrule the advance directive and treat it because the relatives forced me, the law will not give you any protection on that.
Sure.
You will end up being in jail, basically, because offenses and penalties includes a jail term.
Sure.
You see what I mean? So you'll have to tell the relatives that this is the act, this is what the law is saying. Aap karo iske mutabik, aap jao or get the advance directive overruled. And more importantly, the relatives actually have no locus standi. The nominated representative will have to do that. You know what I mean? The NR will have to go and apply, saying that isko overrule karo. And so you just send them off to the board and tell them, get the order from the board, and I'm happy to do what you want.
Correct. Thank you.
That's the only thing you can tell them.
Sure. Thanks.
Yes, Supriya Hegde has raised her hand. You're muted. We can't hear you.
Okay. So thank you for explaining in very simple terms as to how we need to go about. I'm heading a department in Father Miller's Hospital in Mangalore.
Yes.
We have a mental health center where we house many inmates.
Yes.
What I would like to know, sir, like if for somebody, like for an administrator who has to plan, such that our team doesn't get into any legal trouble.
Yes.
What framework should the hospital have? Like I was thinking, but like till now, listening to your presentation, that first we should probably get a signature from all the patients who are getting admitted who are voluntary. Because
Yes,
we also have a de-addiction center. Patients come by will to get admitted.
right.
So first, to try and get a
Well,
probably a
it's
consent
well, it's
form.
not just important to get a signature from them that they're voluntary. You need to
Yeah.
get the psychiatrist to write and say that this person has the capacity to give consent and his consent has been taken. That's very important.
Yeah. So the first thing is the capacity assessment
Yes,
form.
yes,
Second
yes,
is to the psychiatrist attesting that
yes,
voluntary admission is there.
yes, yes,
Suppose there is not a voluntary admission, then make sure that the protocol for assisted admission is
yes,
followed.
yes.
And capacity assessment after, I think, 1 week.
Yeah, 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 yeah.
And then every time keep sending the mail to the board.
Not every 7 days you don't have to send a mail. You just have to send them a mail or send them the information the first time that they're admitted, that you say, listen, this person has been admitted as a supported admission. These are the details about them. This is a copy of the medical certificates. This is a copy of the nominated representative's application. And that's it, really. You do it once. You don't have to do it repeatedly.
So there's no need to do a repeat capacity assessment after 7 days and resend or something.
There is a need to do the repeat capacity assessment and it needs to be documented in the medical notes, but it doesn't have to be sent to the board.
So each and every patient who's not voluntary, who's assisted, every child case this protocol needs to be followed.
Yes, yes. You just have to ensure that every 7 days your psychiatrist is making a note in the note saying this person doesn't have capacity or has capacity. Because if they say doesn't have capacity, then the NR will continue to give consent. If he says they have capacity, then you basically have to now shift their status from supported admission to independent admission if you're going to continue the admission, and you will have to take their own consent for it, you know.
So do we have a template for this voluntary admission and a template for capacity which uniformly we can all follow?
The CMHA, if I'm not mistaken, if you go to the CMHA's website, they made a whole list of forms, you know, for all of these things. They made a set of forms for almost everything that has to be done. And even for the medical certificates, there are forms and everything. So these forms are available on the CMHA's website. And what the CMHA has told all the SMHAs is that you can either adopt our form straight away, or you can make some changes to it and have your own form if you want. But so it might be good to check with your SMHA. Are you using the same forms that the CMHA is given out, or have you got a new set of forms?
Okay. So we have modified some of the forms ourselves, but
Well,
we are
don't do
using the
that.
same template.
Don't do that. Be careful. If you're
Use the
modifying the
same
forms,
template.
if you're modifying the forms, be careful, because ensure that the forms still meet what the law requires. You know what I mean? Because
So
if
most
you modify,
basic
yeah.
structure is the same, sir. It's not like we have worded things differently or things like that.
Yeah, I mean, I have not seen your modified form, so my only concern is ask yourself, why do you need modified forms, you know?
So use the same CMHA form.
You're safe because you use the forms, the same forms. They can't later on come and complain to you saying, oh, you did this wrong or you did that wrong, because you say, listen, these are your forms. I used your forms. How can I have done anything wrong?
Right. Thanks, sir.
Yeah.
So we again have a question from Dr. Rai.
Yeah, Dr. Rai.
Thank you, sir.
I can't hear you, Dr. Rai. You're frozen.
Dr. Rai, sir, please ask your question.
Like, sir, right when patient was writing advance directive, whether a doctor or a psychiatrist or a advocate must be present, or he must be in a healthy state of mind. Who will say this, sir?
They have to register it with the board. It is for the board to take a decision what to do with it. So the board can ask for them to produce a certificate, or the board cannot ask. Basically, the board has to register the advance directive. If the board doesn't register the advance directive, then it is not a valid advance directive anyway. So basically, the board will decide what is the procedure they are going to follow for registering the advance directive.
Okay, sir. Okay. Thank you, sir.
Okay. With no more questions, we can continue, sir.
Okay, okay. I don't have much left. I'll just a few things to go through. Okay, hold on a second. If I can, my screen will be very good. Yeah. Okay, then there are some bits of information that you need to remember. The law has section 20 says that people have a right to protect under the criteria called protection from cruel, inhuman, and degrading treatment, the right to live in a safe and hygienic environment. And there should be adequate provisions for food, sanitation, space, access to articles of hygiene, and also basically you'll have to ensure that all of these things are there, like in your institution. Um there is also a thing that they should not be forced to work in a mental health establishment, and if they do any work, then they have the right to receive appropriate remuneration for the work done. This frequently happens in long stay hospitals where there's always a worry that people are made to do work on the ward under the guise of, oh, this is therapy for them or something, and the law would then really come against you if you were not actually remunerating them for that work. They have a right to information. So basically, the information, what does the information include? So if somebody is admitted as a supported admission, you have to give them a copy of the provision of the law under which they are admitted. Provide information either at the time of admission or later on. And what information do you have to provide? The nature of the person's mental illness, the proposed treatment plan, and the known side effects of the proposed treatment. This has to be explained before the treatment commences, or when you're taking consent from the NR. So again, basically, what this really means is that you need to have your psychiatrist documenting in the notes that, look, I have done this, I have explained it, this is the person, and now I've also taken consent of the NR to do the treatment. So, this needs to be a documentation in your notes that happens. Right to confidentiality, it's very important to remember that no photograph or information about a person undergoing treatment in the mental health establishment should be released to the media without the person's consent. So if you have somebody admitted in a hospital for mental illness, please do not speak to the media about, and ensure that your doctors don't speak to the media about their illness or their treatment or their identity without their informed consent. This particularly happens if you have some celebrity who's admitted, you know what I mean? Some celebrity admitted in your hospital, press come rolling all over, your doctors are very happy to talk to the press, and then they start telling everything to the press, and then you're in trouble because the law says you're not allowed to do that without their consent. There are some exceptions to the confidentiality. One of the exceptions being that if there is some harm to somebody's life or a threat to someone's life, or if the board or the central authority wants information, you have to do it. And then there's a final exception called in the interest of public safety and security, which is a very broad category, largely there because it allows government to ask for information if they want to get information on somebody. Uh, people have a right to access their medical records. So they can actually write to the hospital and say, I need a copy of my medical records. The mental health professional who's in charge, which means the psychiatrist who's in charge, has a right to withhold information. So the psychiatrist can say, you can share the medical records, but this part of the medical records, please keep it away. Don't share it because somebody might be at risk or something. And then you don't share that. So for example, the wife has given you some information about the husband's illness in confidence. You want to protect the wife because you don't want the guy going home and beating his wife saying, why did you tell my doctor this? So you can say, look, I'm withholding this information. I'm not giving you this information. So you black out that part of for the medical records that you do it. And in terms of complaints, people who are admitted under the Mental Health Act have a right to make complaints. The procedure for complaints is very simple. The first stage of complaint is to the medical officer or the hospital administrator or the psychiatrist. If they're not happy with your response, they can complain to the concerned board. If they're not happy with the response of the board, they can complain to the state mental health authority. Okay. This is along with this, they can of course go to the law and get any judicial remedies and all that. That is fine. But basically, there's a process for complaining that they need to go through if they wish to complain. This item covers it. There are penalties for non-registration of the SMHA, and non-registration of the mental health establishment with the SMHA, the owner or the person in charge of the mental health establishment is liable to a penalty, 5,000 to 50,000 for the first time, 50,000 to 2 lakhs for the second time, and between 2 lakhs to 5 lakhs for every subsequent time. There's also a penalty for any medical professional, I mean, any mental health professional, psychiatrist, psychologist, nurse, who serves in a non-registered mental health establishment with a penalty not exceeding 25,000 rupees. So if you're not registered and you have doctors and nurses working in your hospital, they are also liable for a penalty of up to 25,000 rupees. What is the so that's for the registration. Section 108 talks about penalties for contravening any provision, and basically for any person, okay, so everyone is included in this. Any person who has a duty or responsibility under the Mental Health Care Act and contravenes or fails to perform the same is liable to be punished. What are the punishments? The board will decide the punishment and the SMHA will implement it. The minimum punishment is anywhere up a term up to 6 months and or a fine up to 10,000 rupees for the first time, and imprisonment for a term up to 2 years and or a fine of up to 50,000 to 5 lakhs for every subsequent time. So these are the offenses and penalties. If offenses are by companies, section 108(9) covers it. So if the hospital is actually owned by a company, then who is responsible? Then it says a person in charge of the company is basically considered liable for it. Okay, so that would mean the director of the company or whatever who will be considered liable unless they're able to prove that, look, it was committed without my knowledge and that they had done everything to prevent such offenses from happening. So even private hospitals owned by companies get covered. The directors are held liable for the offenses done by people in that hospital. That's really all I wanted to cover for you, because as hospital administrators, these are all the things that matter to you, really.
Sir, we have a question in the inbox by Dr. Musharraf Hossain.
Yeah.
He wants to know about the he wants to know about the website, I guess, website, and where what is the appropriate place from where he could find documents or laws.
You will have to get it from your SMHA. Your SMHA is supposed to, your state mental health authority is supposed to maintain a website, and you'll have to get it from your state mental health authority. But if you just wanted a copy of the forms and all that, the CMHA has a website, I'm told. I haven't looked at it recently, but the Central Mental Health Authority has a website. And you should be able to get it from their website. Whatever they put everything up there on the CMHA. There is a website. I haven't searched for it. I'm just trying to search for it while I speak to you. I haven't looked at it recently. But have a look on the on the Ministry of Health and Family Welfare website. There will be a website. There will be a CMHA website.
Okay, so further, Dr. Supriya Hegde wants to ask some questions. She has raised her hand.
Yeah. Go ahead.
Sir, I think that's by mistake. It was a previous thing.
Okay. Mrs. Chapalgaonkar has a question.
Hello, sir.
Yeah, go ahead.
Yeah, this was really a nice presentation. Thank you for that. I had just one question. Recently, many insurance companies are coming up with patients are asking for their records for getting insurance claim settlement. So what records should we give? One thing. Second thing, should we get any consent from patients or relatives before giving those papers to insurance companies? That was one question. Second question was, is there any mention of number of years for which we will need to maintain our records, psychiatry records in Act? That I wanted to ask.
I don't think the Act, okay, that question is easy to answer. I don't think the Act mentions a number. So whatever is mentioned as a number, in the general acts, you should use that. I don't think the Mental Health Care Act mentions a number for how many years you need to maintain the records.
Okay, sir.
The default would then be look at what the Clinical Establishments Act is saying, use that same number of a number, or if the SMHA has actually said maintain records for X number of years, then do that,
Okay, sir. Okay.
As far as the insurance companies goes, where you have to have consent. In fact, if an insurance company comes to you asking for medical records, they usually attach the consent. They say, look, here is the consent of the patient who has said, please release the records to us. That's how insurance companies function. So you should have the consent. What records should you give? You should give them all the records that, depends on what the patient has consented for. If the patient has given a blanket consent and said, release all my records to the insurance company, that's it. You release all the records to them, whatever are relevant for the mental illness treatment. If they haven't given a blanket consent and said, oh, you can release XYZ records, but not ABC, then you follow that.
Okay, sometimes it gets tricky with the psychometric testing report, sir. Sometimes
you just look, it's very clear. If you have a set of records and if the consent is there to release it, you release the records. I mean, that's it.
Okay, sir. Okay, sir.
There's not, you don't have to worry about the consequences of that.
Okay, sir. Thank you. Thank you.
Sir, Dr. Rajendra Roy has raised his hand. Sir, please.
Sir, thank you for a wonderful act, sir. Sir, are there any shortcomings in this act also, sir? You may have noticed.
The biggest shortcoming currently is that the authorities have been extremely lax in terms of implementing it. So what has happened in, as far as I'm aware of, there are at least 7 or 8 petitions in various high courts. And in at least 3 of the high courts, the high court is monitoring implementation of the act. So like in Karnataka, the high court is actively monitoring implementation of the act. Bihar, last time it came up, the Bihar High Court actually threatened the secretary and said, if you don't implement the act next time, we want you in court and explain it to us why you're not implementing it. One of the other high courts, the Delhi High Court, has also had a couple of cases because of the Mental Health Act. In Goa, the High Court actually passed a judgment against the government and said, if you do not form the mental health review boards within X amount of time, we'll hold you in contempt. And so then Goa finally got their review boards. Maharashtra also, there was a PIL which is still ongoing. So I think the real challenge has been that that people are having to go to the court to get government to do the basic that they are supposed to do, which is setting up the SMHA and setting up the boards. That has been the biggest challenge for me. In Goa, for example, I know a woman who has schizophrenia and her sister went to the High Court saying, look, we want to register an advance directive, but there isn't a board. How do we register an advance directive? So my right to make an advance directive is being violated, and please do something about it. And then the High Court really pulled up the government, and so finally the government kind of had a board in place and got them to give them the opportunity to register. So those have been, so I think, the real challenge has been actually implementing the act. And until we implement the act, we are not going to even know what are the problems that come with it. You know what I mean? Like that's, for me, that is really the biggest challenge at the moment.
Thank you, sir. Thank you. So nice of you. Thank you, sir. Thank you, Dr. Supreet, for this wonderful afternoon.
Thank you, sir. Thank you very much, Dr. Pathare, sir, for such an insightful talk. I'm very pleased that you accepted our request, sir, and spare time from your precious time to speak on the very important and pertinent issue relevant to hospital administrators, sir. Sir, I would request Dr. Mahesh Devnani to conclude the session.
Yeah, thank you, Sukhpreet, and thank you, Pathare sir. And I don't know if words could express, even the AHA president who had joined in between, and Dr. Yashpal Sharma, he had to left because he had a flight to catch. So he had sent a message to me saying that convey my regards and thanks to Dr. Pathare for such a wonderful presentation and a wonderful the way you have presented the act. Most of the time when we listen to the acts, they are like boring, or people are, they lose interest. But I think we had planned it for an hour, and it's an hour and 24 minutes, and we can go for an hour more if you continue to speak. So thank you very much for making it not just interesting. See, so many questions were asked many a times in webinars, people just don't ask any questions. So people are asking question. It itself shows that that you have been so good in presenting all these things to us. So thank you very much, sir. And we would like to continue this association with you in AHA, and would request you if in future also, if we request something, that you would oblige. Yeah.
Somebody's put up their hand just now wanting. Did I see someone put their hand up, or that was accident? Couple of
people are sending you the thanks actually on the.
Okay. There.
Sir, Lajpat
Rai Arya has raised. Dr. Lajpat Rai Arya has raised his hand, sir.
Sir, go ahead. Dr. Arya? You need to unmute yourself, sir.
Thank you very much, sir. Thank you very much. Thanks a lot from bottom of the heart.
Thank you. I've just put my. I have just.
Hans Mishra has also raised his hand.
Yeah, more. I just put my email address. If you wanted to write to me, I put it in the chat. Okay, because people are asking some questions where I'll have to send information. If they write to me, I'm happy to send information.
Wonderful. Dr. Mishra, you want to say something? Dr. Mishra, unmute yourself.
Sorry. Good evening. Sorry, I got late in joining. Sir, I'm thankful to you for this presentation. Just wanted to know one question. Suppose some crime happens, I mean, and the patient is brought to, casualty. And the people claim that the person who is injured is has some mental health issues. So what is the hospital administrator's take on this if we do not normally admit a mentally unwell patient in a private hospital?
If you don't admit a person if you anyway don't admit the person, then where is the question of admitting this person? Because then you wouldn't have the you're presumably not registered then.
But we are when the patient is a little critically injured. So
if wait a second. If the patient is critically injured and requires physical health care, you have to provide it. That has got nothing to do with their mental illness. The fact that they have a mental illness or not is irrelevant. I thought you're talking about admitting them for a mental illness.
No, not mentally illness, but
patient. The fact, if a person is being admitted for a physical health problem, the fact that they have a history of a mental illness is completely irrelevant to that decision.
No, the problem here is that, this mentally ill patients, they create problems for other patients also.
So if they create problems, then you do something about it. But if they're critically,
suppose we do not admit that patient and refer them to some other government hospital or anything, will we be anyway legally responsible for anything?
You will not be legally responsible under the Mental Health Care Act, but you will. Well, you might get some. The only thing about the Mental Health Care Act where you might be legally responsible is, there is a provision under the act called parity. Okay, right to parity, which means that you have to treat people with mental illness at par with people with physical illness. So they could claim that you did not treat them on par because they had a mental illness, you did not attend to their physical health problems. So they could claim that. And the second thing is that you might have your own liabilities which exist for not treating a critically medically ill person, that which might come under any of the medical laws that are applicable to you. Like say under the Bombay Nursing Homes Act or the Clinical Establishments Act, or the Supreme Court has a lot of judgments which say that if somebody is critically ill, you have to treat them for the critical illness. You can't just pass them around. So all of those issues, you could face liabilities on those, as far as I'm concerned.
Sir, if I may
please.
Dr. Mishra, for any physical illness, irrespective of mental health status, we have to provide the basic treatment available to us, and then we can refer. If it is not a specialized center and if there are no facilities available for that, they have to first stabilize the patient and then they have to refer. And but just based
Yeah,
on
that
their mental status, they can't say that we are referring even for the physical
Yeah.
issues, just because
Correct.
that we foresee that the patient might create problem in our
no,
hospital. So that
we we give primary treatment to every patient, whomsoever we are referring. The only issue is whether to keep them in the IPD ward or not. That is the issue.
So what I'm saying is that basically, the mental health care act says there's a right to non-discrimination. If the person says that, look, I was discriminated and not given treatment here for my physical illness only because I have a history of a mental health problem, then you could get into trouble with that, because if they say, look, I have done nothing, but the fact that I had a diagnosis is what is being used against me. You understand what I mean?
Yeah, in any case, we are not supposed to discriminate on any ground, not just the mental illness, race, caste, appearance, sexual orientation.
That Dr. Devnani, that I know as an administrator, the only issue comes, when these patients become a disturbance for others also. And we cannot give it in writing also that we will not admit a mental health patient. But as a norm, as a understanding, we usually avoid that because they create a problem for other patients. That's the one.
If you're, I mean, what I'm saying is that if you are avoiding admissions on the basis that they create problems, you could potentially open yourself up to the idea that you could get, somebody could file against you to the mental health review board. See, I'll show you. It says here, this is section 21, right? I don't know if you can see my screen now, or I'll have to share it again. Can you see my screen?
Yeah, but it's not.
Okay, let me remove this and I will share another screen. I'll show you this section because then you can decide whether you could get into trouble with that section or not. Okay.
Excuse me, sir.
Yeah, hold on a second.
Most of the private hospitals do not usually admit a mentally ill patients because
I know that I know, but what I'm saying to you, I know that. What I'm saying to you though is that you could potentially get into trouble on this. So there's a section called section 21, which is right to non-equality and non-discrimination. Okay, it says that persons with mental illness cannot be discriminated on the basis of blah blah blah. All persons with mental illness must be treated equally with persons with physical illness in the provision of healthcare. Okay, persons with mental illness must be provided healthcare services in the same manner, extent, and quality as persons with physical illness. So now this is going to be your issue. You could potentially run into trouble with section 21. That's what I'm saying. Now, it all depends. Somebody might decide to use section 21 and say, listen, this is why I get treatment. And then that's what you'll have to face up. If they, what happens is if you admit them, and let's say, as you said, they created some disturbance, and at that point you decided to transfer them, then you are safe, because then you say, listen, we did that, but we don't have any facility to take care of somebody whose mental health problem is also serious, and so we transferred them to another place. That I don't think you'll get into a trouble. But if you're just saying we are not going to admit people only because they have a history of mental illness, then you could run into trouble with section 21.
I got your point, sir. The problem happens, that when the patient comes, the relatives, they tell that this is the problem. But if you deny admission due to some reason, then they create a problem. The problem is that.
Well, see, I can only tell you what the law is and what works under the law. Whether the relatives create a problem or not, I can't do anything about. But I'm saying even if the relatives don't create a problem, what I'm trying to tell you is that if you said, oh, we will not admit you for let's say you have a medical problem, but we are not admitting you for a medical problem because you have a past history of mental illness. And because people with mental illness always create problems, so we don't want them at all. Now, if you do that, somebody could take you to the mental health review board or to the state mental health authority and say section 21 is being violated by them. That's all I'm saying.
Okay, great. I mean, nobody will say like that. I understand. So
yeah.
Anyway,
so that's all I'm kind of, that was Dr. Arya's question. I think that will we be in trouble with it? So I'm saying that's the only section you could potentially be in trouble with.
Dr. Abdul Rashid also wants to ask some questions, sir.
Okay. Dr. Rashid?
Yes, sir. Sir,
Yeah, go ahead.
yes, sir. We are very thankful that you are giving us such a good information about mental health and illness. But one question is there: if we will get just you are talking about an emergency. If emergency will come casualty, what we will do? Sir, if we will do, we will for a example, emergency is coming, casualty is coming, and with mental health previous history. Sir, can we go for help from the psychiatrist so that we will get him on board and he will come to casualty and with his help we can go forward.
So listen, I have an answer to this. You answer my question and then I will answer your question. My question is very simple. Let's say you get a woman who comes to your casualty and has a medical condition and needs urgent medical care. But you also know that she has delivered 2 babies in the past. Will you take the help of an obstetrician to do her medical care?
No. First we have to.
No, you won't know.
Act. First we have to act. We have to.
Correct.
This.
So
We
what I'm
have to.
trying to say, the fact that somebody has a history of mental illness is the same as somebody who has a history of having delivered 2 babies.
Yes. No, we will
Yes.
do our work.
You do what has to be done. If the mental illness is relevant at that point in time, yes, please involve the psychiatrist. If the mental illness is not relevant at that point in time, that they just have a history of mental illness, you don't need to involve the psychiatrist. Just like if the woman has bleeding from the uterus, then yes, involve the gynecologist.
No.
If the woman if the
That
woman
is an
has just got a
emergency.
history of delivering 2 babies, should not be the reason why you will involve the obstetrician when she comes to the casualty for an unrelated physical problem.
No. I am telling, sir, you didn't got my answer.
Uh-huh.
That if an casualty is coming, if an emergency is coming, we have to see that. First, we have to deal with the emergency. But later
Yes.
on, if he will disturb us in our
Yes,
admission, he will
correct.
disturb
If
other
that
patients,
happens, you can involve the
then we can
psychiatrist. Yes. So if there is
involve the psychiatrist.
absolutely. So if mental health becomes an issue, then please involve the psychiatrist. Definitely.
Yes. My question was that.
Yeah.
Sir, it reminds me one of your statement that I heard in one of your TED talk, in which you said that next time a patient comes to casualty with the chest pain, call the cardiologist and not the psychiatrist.
Yes, exactly.
Yeah.
Well, I have
Yes,
seen
sir,
this happen a lot. I have seen this happen a lot of times to me when I worked in large general hospitals. If I'm on call, when I used to be on call, I will get a call in the middle of the night saying, please come to the casualty. One of your patients is here. You ask the casualty doctor, what is the problem? Why has he come there? He's come there because he's got chest pain. So why do you want me to come there? Oh, because he's got schizophrenia. But he's come there because he's got chest pain. What will you do for a person with chest pain? You get a ECG done, call the physician. मुझे क्यों बुला रहे हो? But people will say, नहीं, आप psychiatrist हो, आप आ जाओ. So my answer to them usually then is that if a woman comes here in the casualty and complains of chest pain, will you call the obstetrician because she delivered 2 babies last year? I mean, that's ridiculous, no? You wouldn't do that. Why are you doing it to me?
Yeah, correct. So, Preet, should we conclude now?
Sir, we have one more hand raised. It's
Okay.
Dr. Rajendra Rai again. So
Okay.
the presentation is
Go on,
such
Dr. Roy.
interesting.
Let this be the last question, okay?
Okay.
Right, sir.
Dr.
Dr.
Rai,
Rai,
you
sir.
get the last word.
Or it was accidental, I guess.
Okay. Dr. Rai is frozen. I can't hear him.
So, Preet, you can-
Okay.
Sir, really thank you. Thank you from the core of the heart. It was really a very nice presentation. In a webinar on administrative act or law, we have got such an interactive session, and I have never seen like this, sir, before. Really thank you. Thanks a lot, sir.
Thank you for asking me. Thank you so much. Thanks for giving me the opportunity. Have a good weekend.
Thanks to all the audience also for being so active today.
Okay.
Thank you.
Have a good weekend. Bye-bye.
Thank you. Bye.
Bye-bye, sir. Thank you, sir.
Thank you, sir.